are very experienced practitioners. In fact, Mr. Daniel and Mr. Kevin have also been involved in training adjudicators before, and they have been doing review of cases and all that earlier for the last few years. Most of you are aware that adjudication has been around. I think this year it was gazetted in 2014 April. This year is going to be exactly 10 years. So there have been a lot of cases and a lot of developments, some very surprising to all of us, because being adjudicators, we never thought that it would go this way. Adjudication has become very, very legal, and we can see it also from the participants today. I think almost, 80% are actually lawyers, okay? We are very honored to have a judge also who has actually logged in to listen to us. We also have some quantity surveyors. I think we have got 2 architects, okay? We also got some engineers, and I think the participants geographically are also quite spread out. Quite a number are from East Malaysia, mostly Sabah. We also have from Peninsula. From Peninsula also, we have people as far as Penang who have logged in, which is a very good sign. So that shows that BICM is actually being known to a lot of people outside East Malaysia, which is a very good sign. So what I'm going to do is I'm going to go through some of the questions. Some of these questions actually taken from practical cases. We are just relating the facts to you. Some of them basically also are from recent case law, the developments. There have been quite a number of cases. 3 weeks ago, I think we had a very interesting federal court case, which we are going to talk about it. We also had some interesting Court of Appeal cases. Some of these cases were reviewed last week at the Society of Construction Law Conference in Kuala Lumpur. So I think these are quite pertinent. For non-lawyers, please don't be intimidated. As far as adjudicators are concerned, so long as you follow the principles and more important, the procedures, I think you have nothing there to worry. Okay. But anyway, we will go through. We got a bit of limited time, so we may be only able to address some of the important topics that will come about. So let me start off. One of the starting points of adjudication is your Section 5 and Section 6. Okay, the payment, claim, and response. Now, the first issue that comes about, especially Section 5, is it a mandatory requirement or directory requirement? Okay, if it's directory, can the adjudicator use Section 26 to cure any default or omission? If you look at Section 5, for example, there are 4 requirements there. Okay, so can you cure that? Now, if it's mandatory, okay, what are the effects on the jurisdiction of the adjudicator? I'm just putting it in a very some sort of a general form where we can invite discussions from the panelists. So, Mr. Daniel, do you want to give us your views first?
Yeah, sure. Thanks, Harbans. Well, Sections 5 and Section 6, I think, have to be regarded as very important clauses. The way I read it is that it actually sets out the main jurisdiction for the adjudicator in respect of the issues that have to be decided by the adjudicator. So the adjudicator has to be very careful to be able to ascertain exactly what his remit is in terms of the disputes are. So how strictly we interpret that, I think we've got a couple of court decisions on that. But perhaps I won't go into the details yet. Maybe I'll just ask perhaps Yuen Fong and Kevin to share their views on it as well.
Kevin, you want to go first? You're muted, Kevin?
Thank you, sir. Thank you. If I may just add some context, and this is mainly to the non-lawyers here, but also to the lawyers here as well. We must understand that a lot of how we approach Section 5 and Section 6 today has to do with the impact of what happened with the federal court decision in View Esteem in 2018. You see, when the Act was first passed, the way we read it was quite clear. Section 5 says, look, payment claim, you have to state all these items in the payment claim. Section 6 says that if you were going to reply, you're going to dispute a claim, that you have to actually state that you disputed and the reasons for stating it. And reading it together with Section 27(1) and Section 27(2), the Act says that, look, the jurisdiction of the adjudicator is limited to those matters raised in the payment claim and payment response in Section 5 and Section 6. It was always very clear to all the practitioners out there, to lawyers, as well as to adjudicators. In fact, the adjudicator followed the tone and the theme of Section 5 and Section 6 and Section 27 in the View Esteem case itself, the adjudicator. Obviously, the employer and the project against whom the adjudication decision was made in View Esteem challenged it, brought it up to the High Court to say, look, there were some items that were not in the payment response, which had raised in the adjudication response though, and it should have been taken up and considered by the adjudicator. And the High Court said, no, you're limited only to whatever it is that you have said in your adjudication response, sorry, your payment response. Court of Appeal agreed, but then when it went up to the federal court said, look, no, not necessarily so. And that was, it was only at that time, people's views, all our views and understanding of how to approach Section 5 and Section 6 took a bit of a turn. And I don't really want to use it this way, but we began to look at Section 5 and Section 6 as if they were not as important as they were before. Because the court in View Esteem said, look, if certain items are raised in the adjudication response by the respondent, that the adjudicator must and should consider all those items that are raised there. That was really the basis and what set the stage for a lot of the claims and cases and references to adjudication, as well as challenges to the High Court after that from 2018. But you will see still that there are a lot of challenges that have been taking place and which led up to this ANAS construction case that Mr. Harbans had raised, which was a discussion on Section 5 and Section 6. And of course, all sorts of arguments were raised, starting from whether or not a particular clause on which the claim for payment was made was referenced at all in the payment claim, which was not taken into account by the adjudicator, because the adjudicator in that case went on and referred to some other clause in the contract altogether and gave X amount of money. High Court agreed with the adjudicator. Court of Appeal disagreed, and ultimately the appeal to the federal court was dismissed. And it goes back again to what Mr. Daniel and Mr. Harbans had emphasized earlier on. At the end of the day, notwithstanding what it is that the federal court said in the View Esteem, the point I think that we all should take home is simply this. At the end of the day, Section 5 states as clearly as day and light really what should go into a payment claim. And it says in a payment claim that in these 4 items must be clearly set out, which is the amount claimed and the due date, details to identify the cause of action, and the provision in the construction contract for which the payment relates. So the point I'm just trying to emphasize here, given the ANAS construction case in View or View Esteem, is simply this: instead of all of us here discussing the finer and the minute points behind ANAS, behind View Esteem, we as lawyers and counsel, we should just comply with what the Act requires. If the Act says set out the amount, set out the due date, set out the cause of action, and set out the clause in which the claim for payment is being made, that's all we need to do. Practically, that's what we need to do. Follow the Act, comply with the requirements, and this is how I think, and this is my view at least, we stay out of trouble. The adjudication decision will be upheld whichever way it goes, and we will not have our case, discussed in court. That's my view, Mr. Harbans.
So are you trying to say that the requirements of Section 5 and 6 are mandatory? Section 5 is mandatory, Section 6 is not mandatory?
Because of view esteem, sir, because of view esteem,
No. Now we come back to Anas because, okay, view esteem was an earlier case, you see. The latest case now is federal court decision in Anas.
Okay.
Whether we like it or not, of course, there was a dissenting judgment by Yang Arif.
Justice Mary, yes.
Dato' Mary Lim. If you ask me personally, I prefer the dissenting judgment, okay? If you ask me personally, because I feel it's more in line with what adjudication should be. But since we got a majority decision, until this decision is revisited, we are bound by this decision. So now, following this decision, going back to the question I asked earlier, is the requirement of Section 5 mandatory or directory? Sorry? Sorry?
Someone said something?
Yeah. Wait, I'll come to Mr. Yuen Fong later, Mr. Kevin. So is it that mandatory or directory?
As it stands right now, sir, I still hold with the view esteem in that it is not necessarily mandatory.
Not necessarily mandatory.
Yes.
Okay, Mr. Yuen Fong, what are your views on it following Anas construction and JKP? Majority decision, we are looking at a majority decision. So is Section 5 mandatory?
I would agree with Kevin that it's not mandatory. However, because we as practitioners, we have to comply with the Act, we have to list out whatever is stated in Section 5 and Section 6. We have to look at, from the point of view of the parties who are not represented. Now, the courts have to bear this in mind, that if a party who is not represented drafts the payment claim, all they can do is just follow what the Section 5 says. And I don't think you can fault them for that.
But doesn't that make the requirements there mandatory? I think it was earlier even, I can't remember the case offhand. Our Yang Arif, Dato' Lee Swee Seng, in one of the cases held that it is a mandatory requirement, okay? Especially meeting the 4 requirements, and it affects the core jurisdiction of the adjudicator. And I think, if I'm not mistaken, the majority decision in Anas construction also is talking about the same thing, you see? So, I don't know. Also, if you are saying that it's not mandatory, then it's directory, then my next question will come in. Then can you use Section 26 to cure any default?
Okay. I would follow Justice Mary Lim's dissenting decision, because what she said was the payment claim was still the initial stage. It is akin to a letter of demand. You're putting the respondent on notice to tell them, like, look, this is my claim, and what is your response? Now, Section 6, of course, says if they don't respond, it's deemed that they dispute the claim. So only after that, then only it goes for adjudication. It's not an adjudication process yet. It's just a putting the other party on notice.
But then coming to that, if you miss out something in Section 5, can you pick it up later when you put in your adjudication claim, Section 9? Say, for example, there was non-payment for work done, but there was also items of variation. You missed it out in your Section 5 claim. Can you then bring it in Section 9? I mean, if it's not mandatory, like what you're saying, I can always bring in under Section 9 now. Then I can argue you can use Section 26 to cure it, isn't it? But I don't think so. I don't think so. A whole series of cases have allowed that. They say that can't be done, isn't it? Mr. Daniel, what do you think?
Yeah, I mean, just coming back to the Anas decision as to whether it's mandatory or not. My reading of the decision is that the Section 5, Section 6 requirements are mandatory. I find it difficult to reconcile with view esteem, because view esteem, I think in part they said it's mandatory, but when it comes to defenses, which includes set-offs and counterclaims, it's not mandatory in that sense because of natural justice. So I do have some difficulties with it, but from my reading of the ANAS, it is mandatory. Now, when it comes to trying to make a correction later on by the adjudicator if there's any irregularity in relation to sections 5 or 6, I don't think it can be done because at the time when the irregularities were committed, there was no appointment of the adjudicator. Like Yuen Fong pointed out, the adjudication process hadn't really commenced yet. So the question is whether the adjudicator has the power to almost retrospectively, go back to a time when he wasn't even appointed as an adjudicator to make a correction to Section 5, Section 6. I think it's doubtful. I also think it's dangerous because Section 5, Section 6, as I mentioned earlier, to me, it touches on an area of jurisdiction. And when you make a correction on jurisdiction, are you then not making a decision in your own jurisdiction? Yeah, so that's how I look at it. Maybe I don't have the right answer for this, but it's certainly some concerns.
I think what you are saying, you see, if you read ANAS, the federal court was saying that the impact of non-compliance, Section 5, Section 6, on jurisdiction, they relate it back to Section 27 and 1 and 2, okay? And to me, that goes to your core jurisdiction, isn't it? You see? It goes to a core jurisdiction. Of course, they have another issue of breach of natural justice. That was more for setting aside, isn't it? Yeah. So if you would ask me, this is my humble opinion as a lay adjudicator, I would agree. 26 cannot actually cure. If, for example, the requirement Section 5 and Section 6 are mandatory, I don't think so. You can use 26 later to try to cure any deficiencies, especially the 4 requirements, that have been set out in Section 5, notwithstanding the fact that, what in ANAS says, in ANAS construction, they say, Section 5 is only equivalent to some sort of a letter of demand, you see. It somehow actually circumscribes the jurisdiction issue, you see. Okay, one last comment from Kevin before we move on. Otherwise,
I was just about to agree and echo what both you, Ms. Harbans, Daniel and Mr. Daniel Mr. Tan had said, which was you cannot cure any irregularity vis-a-vis Sections 5 and 6 under Section 26. And if you look really at Section 26 alone, it says subject to Section 2, non-compliance with the parties with respect to the provisions of this Act, whether form or content or in other respect shall be treated as an irregularity, shall not invalidate the power of the adjudicator to adjudicate the dispute, nor nullify the adjudication proceedings or adjudication decision alone. So I just do not see there being an avenue, an opening to actually regularize an irregularity. It really is a question as to whether or not the power of the adjudicator itself can be brought to an end. But if I may just emphasize this one point, given the entire discussion that we've had on just this one case, ANAS construction, on the question as to whether or not Sections 5 and Section 6 is mandatory, in the light of Section 27, how ANAS in the federal court had framed its decision, going from the question as to whether or not there's compliance with Sections 5 and Section 6, and marrying it with the question of jurisdiction as well as procedural unfairness, which is a breach of natural justice. I just like to emphasize this again. Instead of all of us falling into that, as lawyers, comply, follow Sections 5 and Section 6 to a T. That's the point, really, that I think all of us here are trying to say. Don't let our cases go into court and let it be discussed among the judges as to whether or not a decision ought to be set aside or to be maintained. Just follow Section 5, just follow Section 6. Really, which is what you need to do. If you have it, always err the side of saying more. If you have 4 clauses in the contract that you might want to rely on to pursue or to advance your client's case for a claim, set out all 4. It doesn't matter. In ANAS, what happened? They mentioned 3, but the adjudicator went for some clause 36, which was not even mentioned at all. So the point is, state the clause, follow Section 5 to a T, and try to reduce the possibility of any successful adjudication being or coming under attack. That's all I really wanted to say.
Mr. Yuen Fong, before I close off this, your thoughts?
Yeah, I'm of the view that if the parties, notwithstanding that, say they've raised 5 issues in the payment claim, during the adjudication claim and the adjudication response, another issue comes out, new issue. Both parties address it, both parties submitted on it. The adjudicator still has to deal with it. So even though it's not stated in the payment claim, I still think that whatever issues brought up in the adjudication claim and the response should be dealt with by the adjudicator.
Okay.
It has to.
Okay, I'm just going to summarize the whole thing. I mean, from the discussion, the way we look at it, and I keep on coming back, to this Anas construction case, although I am quite impressed with the dissenting judgment written by Young Arif Dato' Mary Lim. She, having sat in the construction court, has got a benefit. I think her understanding of adjudication, statutory adjudication, I think I feel is much more deeper. I would tend to give a lot of weight to her reasoning. But having said that, since we got a majority federal court decision, it binds all of us until it's set aside. That being the case, I think you have to take these requirements as mandatory. Okay, and I think you cannot use Section 26 to cure it. Okay, so in that sense, because we were talking about lawyers and this and that, as an adjudicator again, when it comes to you, because this involves an adjudicator, when you think it doesn't comply, that means it affects your jurisdiction. And if you go on a frolic of your own, the term they use it, okay, in my lineup, there was a breach of natural justice, and the whole thing will be set aside. First thing, one for want of jurisdiction, the other one, breach of natural justice. So those of you who are lay adjudicators here who are not legally trained, okay, again, same thing what we mentioned, on the side of caution. Okay, go through it. Okay, give whatever reasons. You don't have to go into very legalistic. Get submissions from the parties. Important thing is what those who attended our courses also know. We kept on emphasizing. Listen to both sides. Don't make a unilateral decision. Okay, don't be in breach of natural justice. You've got to be fair to both sides. So I think roughly in a way I summarize this. I got one more issue on this Section 5 and Section 6. Before we go on to the next topic is, I was told, I had an experience before, but I was recently told by one adjudicator, he received a Section 5 notice from one of the parties, the lawyers. The Section 5 notice was 210 pages long. Gentlemen, you tell me, is there a necessity for Section 5 to be 200 over pages long?
No.
No, I mean, I can't blame lawyers are used to drafting like that, if you look at all the standard forms, even AIC developed, it's just one sheet of paper, isn't it? You don't have to put all your facts there, all your arguments there, isn't it? So long as you comply with the 4 requirements. So quickly, Mr. Daniel, your comment. After that, Mr. Kevin and Mr. Yuen Fong, what is your view on it? Because for the benefit of lay people who want to represent themselves, like I got one case, where one side got a lawyer and the other side didn't have a lawyer, When 210 pages came, the guy panicked. Actually, he wanted to answer on his own. So he had to employ a lawyer to answer. And the lawyer came up with an equally lengthy kind of, So a lay adjudicator can get intimidated. On one side, you have a 210 pages and the other side is only 2 pages, So, Mr. Daniel, your views?
Okay. I'm certainly not one in favor of verbosity. I think those of you who have been involved in cases that I've done will know that I like it short and sweet. Yeah, I can't see any reason why a payment claim should be 210 pages long. I mean, unless you've really got so many issues, which I doubt. Often when you actually narrow down the issues and dispute or the causes of action, there's usually only a handful, So yeah, have a look at Section 5 and look at the way it's structured. Look at the requirements and ask yourself, do you really need 210 pages to set out the claimant's payment claim? That's all I can say. But also bear in mind later on when adjudicators go through all those issues, 210 pages long, yeah, I don't think you're doing yourself any favors. Adjudicator is not going to spend much time going through all that material. Kevin?
Absolutely agree and echo Mr. Tan's views. A payment claim, as the federal court even said in BOS team, it is akin to a demand. Set out what your claim is, follow Section 5. It literally gives you the entire guide in Section 5 itself. How much, when due date, cause of action, the clause in which you seek payment. Just set out those items and issue the payment claim. You're not doing yourself any favors when you expand the payment claim so much to a point where the adjudicator may have to deal with such an overly expanded jurisdictional box for him or her to work with. That's really my view. Keep it short, sweet, set out the demand. You can say all that you want to say in the adjudication claim itself.
Mr. Yuen Fong, your views, please.
Yes, keep it short and sweet. But I was thinking, probably the lawyer who drafted the 210 pages did not want to spend time to do the adjudication claim, so he did it in one go.
Okay, yeah, I agree with what has been said. Now, just to summarize it.
Sorry, Mr. Harbans.
Yeah, okay.
I just talk about Section 6.
Yeah.
What can we discuss about this? What happens when the respondent does not, respond? So if it's mandatory that they raise an issue in the response, and if ANA's case says it's mandatory, how are they going to do it in the adjudication response? Because they've never said it.
No, Mr. Yuen Fong, I think if you read ANA's carefully, the emphasis was more on Section 5, Section 6 just in passing, okay? So I feel you have two, you got view esteem, which went to great, view esteem was basically on Section 6, okay?
Yeah.
It's laid down certain guidelines. Here, you look at ANA's was basically Section 5. To me, if you ask me, view esteem was, as far as Section 6 is concerned, view esteem will still apply. They can keep quiet. Later on, they can throw the entire kitchen sink at you, We can't help it unless there's clarification in a further case. I think that's what they can do. And that's what is happening now, you see.
Yeah.
That's my view, That's my view, Okay,
Yeah,
I might be wrong.
I do see Yuen Fong's concern there, though.
Yeah.
I do see Yuen Fong's concern because it's double standards. The standards for Section 6 are very different to the standards for Section 5, which is why I've got difficulties reconciling parts of US team and the ANA's decision. But anyway, that's for another day, debate for another day.
Okay, I'm having a bit of a background noise here going on. Okay, just give me one moment, please. We've been having dengue cases here and they're fogging this whole area. Okay, so let's move on. Let's move on now to another area which actually affects a lot of... now, before I go there, now, in cases where people give you a very lengthy Section 5 and Section 6, as an adjudicator, one of the way you can exercise your power is when you're taxing the costs, okay? You can actually don't give them the cost asked for, because they actually, anyway, they can pick it up in Section 9, basically to amplify the whole thing, isn't it? So one of the way you can actually, I think you can do it is, when you look at taxing the cost, you just give them, don't give them an indemnity basis, and then only what you feel is reasonably necessary under the circumstances. That's what I would do. Now, quickly moving on to the next thing. Now, one of the biggest problems which a lot of adjudicators have is, under Section 25, they are given the power to limit the submission of documents. Okay? They're given the power. Now, what happens if you limit, like, there was a case, loss and expense, 25 million. You are an adjudicator, you have to make a decision. So you put a limit to it. Say, okay, I will only allow 4 bundles of documents, how many pages, this, that, and all. Then what happened? The parties dump on you 25 boxes each. So what are you going to do? I know there's English case law saying you only look at the first few cases, this and all that, But we have lawyers who have threatened the adjudicator. If you do not go through all our bundles and all that, you're in breach of natural justice. And that's one ground we're going to challenge you. And so the poor adjudicator is intimidated. It's got all these boxes. It's ridiculous. 45 days to go through that. Even in arbitration, you really can't go through that, right? And it happens, and again, you must also realize, so it happens 2 reasons. When parties reach that stage, they're already in dispute. They prepared all their documents. So what they do, they dump on the lawyers. The lawyers take it and they dump it on the adjudicator. Now, what would you do in that situation without being in breach of natural justice? Mr. Daniel?
Well, okay. I mean, the approach I've taken in the past is that I try not to discriminate between parties who submit very bare sort of core bundles against parties who dump everything. And the reason I say that is because there's always a risk. To me, it's a risk that if you try to curtail the number of documents that a party can submit, then those accusations of breach of natural justice arise. So the way to navigate around that, I think adjudicators need to be a little bit streetwise by being selective what they want to look at. All right. I think through your own experience in handling previous cases or other matters, you should be able to try and pick out what are the core documents that you want to look at and filter out the not so relevant, voluminous documents that are often not necessary for the adjudication. I know it's not an ideal situation to be in, but sometimes you just got no choice because the parties don't follow your directions. Yeah, that's all I have for now, Harbans.
Kevin, your views?
Agree. I take the same view as Mr. Daniel Tan. I've had two competing situations. One before where I was acting as counsel and I had a adjudicator limit the parties to submitting up to a maximum of 100 pages of documents only. But we didn't complain, and I was acting for the claimant, and we just complied. And we did whatever it is that we could to keep it to the 100 pages, as difficult as it was. And what we also did was, instead of, for example, putting in an entire document which would have been 100 pages long or 200 pages long, we only submitted those relevant pages so that we could bring it to under 100 pages. So at least on our part, we just complied with the direction of the adjudicator, and I'll suggest this to all those here who act for parties. It goes a long way if you were to comply with the directions of the adjudicator, because if she or he wants it to be under, let's say, for example, 4 bundles, it helps to keep them on your side, to keep the adjudicator on your side, and not to get the adjudicator upset with you for any unnecessary reasons. But as an adjudicator, I've also had the situation where I've literally received 600 pages in total, 600 pages of submissions, added with 400 pages of submissions by the experts. I had to go through 1,000 pages of submissions, but I did not limit them, and it just adds to the entire amount of work. But I chose to err on the side of caution, so I took into account all 1,000 pages of submissions and documents, and I put out a decision. But that's just my view, and I just decided to play it safe. Ms. Harbans?
Yuen Fong?
Okay. For the adjudicator, yes, he would have to set the ground rules, because I think he has to emphasize to the parties that they have to know CIPAA, the purpose of why CIPAA was enacted. There's the swiftness in the decision, which everybody needs to alleviate the payment. So I think the adjudicator, yes, it's a fine line to limit the documents to be submitted, but I think that adjudicator has to put his foot down somewhere, you know. If not, it's not going to be render the award proper in a certain way. But if possible, like Kevin did, he went through everything to earn a side of caution. Yes, some adjudicators would do that, but maybe the majority of them would not. So it's a fine line. I think the adjudicator would just have to set the ground rules out from the beginning and limit the number of documents. Keep it to the issues which are in dispute.
Thanks, gentlemen. I was just thinking aloud, because at the moment we're looking at only adjudication under CIPAA, but we know they also contractual adjudication. For example, our PAM contract has got now, even started off quite some time ago. We also have ad hoc adjudications. I do not know whether you as adjudicators practice this. In all my adjudications, I always try to hold a preliminary meeting, just like arbitration. Okay, I know a lot of adjudicators, they just give direction straight away, you know. So the main reason I actually hold a preliminary meeting, or some people say preliminary conference, is what? If one side is, if both sides are represented by lawyers, it's okay. If one side is represented by a lawyer and another one is not, there is a bit of a problem. If both sides are not represented by lawyers, even it's a bigger problem, because they don't know what an adjudication is. So at the meeting itself, you know, you are the master of the proceeding. Section 25 gives you the power, you see, act as a master. And at the meeting there, before you direct, explain to them, listen to them. Like, for example, one of the areas, I think you will agree with me, where we have voluminous documents is final account claims. Okay? Final account claims, the sums are quite substantial, and there are a lot of claims there. So final account claim, you have a lot of documents, for example, and like, for example, if there's a loss and expense claim again coming, or some claims has to do with prolongation and all these kind of things, parties want to put in the invoices, you know, real evidence, you know. So these are like kind of areas where I think before you issue a direction, nowadays you can call a virtual meeting. We call a virtual meeting. Okay, we have done it internationally also, international clients. Go through, listen to them before you issue your direction. Because if you talk to them and then come to some sort of an understanding, let them know what it is, you know. You have to be very frank with them, because a lot of people are now treating adjudication as fast-track arbitration, you know. It's just like that. It's no different than that. But it's far from that. So at this so-called virtual meeting, one of the issues, there are a lot of issues, I have no time to go through it, is one of the main issues we look there is how to handle documentation. Because I'll be very frank, I always tell the parties, you dump too many documents on me, you know, most of the time they don't even refer to it. Look at arbitration, how much? 10% documents only, they look at it. I'm not going to give you the cost, you know. So you are actually doing a lot of work, you're dumping a lot of things. I don't have time to go through and come up with a proper decision. So after having this kind of understanding, then only you issue a direction. Because if you just issue a direction, sorry to say, I mean, lawyers also doing their job, it's their job, you know. And if they find an adjudicator who can be intimidated, they will write a letter, you are not allowing me to ventilate my case. This is a breach of natural justice, right? So what happens? One party only put in, say, 2 boxes. Now he puts in 20 boxes. The other party makes an application for you. I want to put in another 10 boxes. What are you going to do? You're caught in a big problem, and you got a very strict timeline, you know. So my way of looking at it, the way I feel, I mean, up to y'all panelists whether you agree with me or not, is I feel I mean, we should have some sort of, I mean, you got to be in control. If your directions are clear enough and, you know, parties are not going to argue too much, it's okay. But you'll always find one party, especially the respondent, will always create problems. That is their job, you know. They'll create problems for you. And then you come up with all kinds of applications coming in, you know. I had one adjudication matter, before I could even start writing my award, I had 26 directions to issue, you know. with even some of the lawyers coming and asking for further and better particulars, First time I heard about it in adjudication, Okay. You can't, you see, they're right to you. You cannot just keep quiet, because if you do that, this will be raised up later. And sometimes these are used tactically actually to intimidate the adjudicator. Especially, if you have somebody like me, and at the beginning you have a title IR, they know engineer, can bully, I'm not saying that everybody do, but to summarize it, you want to master the proceedings, you set the rules, but explain the rules to parties. Because I think if you explain to them, everybody is a professional, Even if you're not represented by a lawyer, you're represented by a claims consultant, an engineer QS and all that. They're also professionals. They also know where it is coming from. So I think that would be a good way, But I think you have the power to limit if you feel it's necessary. Then there's a risk, Then let the court decide whether you're really in breach of natural justice or not. That's one of the risks you got to take. But you cannot be intimidated. I've heard of cases where suddenly the documents came in, the adjudicator panicked and resigned. Then what's the whole point of having adjudication? Then you got to start the entire process again, So, so gentlemen, your views. One simple sentence from each one of you before I move on.
If I may, Harbans. Yeah, I think I totally agree with you. It's not an ideal situation. And again, it comes back to the issue of, if you dump too many documents on an adjudicator, you don't expect the adjudicator to really give you a thorough or proper decision. If you bombard the poor guy with too many documents. So you really need to assess the situation and decide whether adjudication is really the proper forum for that sort of a dispute. And yeah, you're doing yourself no favors if you dump documents on a adjudicator like that. Yeah,
but Daniel, do you call for a preliminary meeting? Do you hold one?
I generally don't. I generally don't. Because yeah, I generally don't.
No, I agree with Daniel before I go to Kevin. Sometimes it's quite dangerous to hold a preliminary meeting, especially when you have very powerful legal eagles representing, They'll start raising all kinds of, issues from the very beginning, We'll try to scuttle the whole proceedings. But I think you can handle the situation. If you're professional enough, you can handle it properly, I mean, all is up to you, preference. But my style has always been, try to talk to the parties, first. Okay, Kevin?
I've not called for a prelim meeting before, but perhaps I should consider doing this because I see more so now than even before, the sheer amount of documents that are coming in now are getting more and more voluminous. So perhaps we should start taking greater control. I agree with you, sir.
Yuen Fong?
Yes, on my part, I've also never called for a preliminary hearing, but it could be useful. Maybe it depends on a case-to-case basis.
Okay, thanks. Okay, so let's quickly move on to the next issue. One of the problems a lot of adjudicators, if you look at section 22 and 23, you're an adjudicator, okay? You have been either nominated by the parties or nominated by the director of AIC, and after that you have 10 working days to actually negotiate and come to an agreement of a fees, okay? You need not necessarily follow, the one that's in the under the regulations itself. You can always negotiate any fees, okay? Now, you try to start negotiating. You have 10 working days. Before the 10 working days are over, the parties come to you. They say, sir, we need a bit more time to come back to you to say whether we agree or disagree with whatever you propose. Now, question is, do you have power to extend the 10 working days? Do you have? How will it affect your appointment? Mr. Daniel, sir?
Yeah, based on my readings of sections 22 and 23, I don't believe the adjudicator has such a power to extend the time. And I've faced a situation in the past in a couple of appointments, and the position I've taken is that if there's going to be any extension, it has to be by consent of the parties. And that means consent from both parties, not just one party. So there was one matter where both parties, in one of the cases I was being appointed, both parties agreed to a short extension. No agreement could be reached on the fees, and not even the standard fees prescribed by the AIC. And as a result of that, I just declined the appointment due to the fact that there was no agreement on my appointment or agreement on my terms of appointment.
Okay, Kevin, what's your view?
My view is no, there is no power to extend, even by agreement. Respectfully, I say so, even by agreement. Unlike, say, for example, Section 12, the delivery of the adjudication decision. Although there's a strict 45-day time limit, there is still room to extend it just by a little bit more, I think, but by agreement of the parties. But I do not see there being any room for an extension, even by agreement of the parties under sections 22 and 23. Section 19 says that in the event there is no agreement by the parties on fees, the standard fee and the standard terms of appointment will apply. That's section 92 of the Act. And normally what I do is I will try to propose my terms within the first or second day of the 10-day period of the negotiation period. I will wait for the parties. I will prompt them if I need to, but by the 9th day, if I don't hear from them, I will issue my Form 6 on the 10th day, setting out sections 19, saying that the standard terms and the standard fee will apply, and to get on with it. I've had one instance once where even on the 9th day, when one of the two parties came back to say they wanted a fee even lower than the standard fee. In fact, if I remember correctly, I think one party just wrote back to me to say, can we have a discount? The moment that they said that, I knew they were not even going to agree to the standard fee. I declined the appointment at that point of time, even within the 10-day period, because it was going to end up being a horse trade at that point of time. So I had to decline, so that we will not end up getting stuck with my appointment and parties not even wanting to proceed even on the standard fee, to give them an opportunity to go and see whether they can get an adjudicator who will go even lower than that.
Okay, thanks, Mr. Yuen Fong. Your views?
My view is that the adjudicator cannot extend the time, because he hasn't even accepted his appointment yet, so he's not in a position to extend the time, even with the consent of the parties. So if the 10 days are up, I think the parties have to restart the process of appointment of an adjudicator again.
Thank you. I tend to agree with Mr. Yuen Fong and Kevin. Looking at the provisions carefully, I think that 10 days are mandatory, cannot be extended. Even if the parties agree to extend, cannot. I don't think so. There's a provision. As rightly pointed out, Section 12, for delivering of the award, yes, you can. Parties can both agree. But here, the right at the very beginning, and as an adjudicator, what jurisdiction do you have? You don't have any power whatsoever to do. You can't do that. And this is the sad thing, and which is happening around, is one of the parties will always not respond. Okay, and sorry if I'm going to offend anybody. One of the biggest culprit is the government. You see, the government always got no money even to pay the deposit also down the line. You see. So if you are the adjudicators, you've got an adjudication involving the government, you should already be prepared to get it at a standard fees, Nobody is forcing you to accept the appointment, Okay? But if you do, okay, you must be aware that, a lot of times what happened, the respondent is the one who plays quite difficult to get, But I had one case, just like what Kevin mentioned, it was one of the parties, not only wanted a discount, was asking, is there any LAD they can impose on the adjudicator? I don't know which lawyer bureau was advising them. They want to put it. So I wrote back to them. I said, then in that case, can I have a bonus clause? I also want a bonus. I was just toying around with them because I knew from day one, this adjudication is going to be a disaster. You can already see, when parties start doing all kinds of this rubbish, better keep your high blood pressure down, the money you're going to earn is not enough. You're going to pay for your medical fees. So again, as I said, just to conclude it, you have no power to actually extend time. You can't, even if the parties agree. Elapses, gone. They're going to start all over again. Can't help it. Okay, now let's quickly move on to next issue. Now, one of the problems facing a lot of these lay adjudicators is one of the parties insists he wants to have a hearing. Okay, now you an adjudicator. Under Section 25, you have the power to order hearing, limit the hearing days and all that. Now, how do you exercise it? What are your views? Is it mandatory if one party applies to you? Or should both parties apply to you? How do you exercise? Actually, it's a power, it's a discretionary power, And I think that discretionary power has got to be exercised on reasonable grounds. You must be able to justify. If you say no, you have to. Because if you don't do that, parties are going to take you up for breach of natural justice. It happened in a couple of cases. I think there's one case where the Court of Appeal agreed, that the adjudicator, there was a breach of natural justice when denied giving hearing when one party asked for it. So, Mr. Daniel, what's your view?
Well, yeah, I'm aware of the cases by the court saying that there can be a breach of natural justice if you don't call for a hearing. The approach I've taken all along is that if there is going to be a hearing, it's actually for the adjudicator's benefit. It's not for the benefit of the parties. That means, does the adjudicator, do you as an adjudicator need the clarification by way of an oral hearing? More often than not, I will decline these requests because based on the applications that I see for hearing, it's usually just another forum for the parties to ventilate their arguments, which have already been canvassed in the sections 9, 10, 11 submissions. So on that basis, I'm usually very reluctant to have a hearing unless I feel that I myself require clarification on the section 9, 10, 11 submissions already made by the parties.
Thanks. Kevin?
Fully agree with Mr. Tan. The discretion lies with the adjudicator alone. It is not a right or an entitlement of the parties to have a hearing. And exactly what Mr. Tan had said, more often than not, the request is merely just to re-ventilate what is already there in the adjudication claim or adjudication response. I've had opportunity of, at least as sitting as adjudicator, I've had several requests for hearing, and I've turned most of them down, save for two. One was my very first adjudication, so given that it was my first, I agreed to the party's request, mainly because it was a joint request, not a request by just one party or the other. But otherwise, I've turned down other requests for hearings.
Thanks, Mr. Yuen Fong.
For me, I've never had a request for oral hearings, but if there was, I think we would have to, as adjudicators, we would have to see whether it is what the purpose is. If they are just there to vent their frustrations and all those things, then I don't think we should allow it. I think because when we get all the documents, we would roughly know whether an oral hearing is necessary or not. Yeah. Because I think 90% of the CIPAA cases are done just by documents only. So ultimately, it is the discretion of the adjudicator to decide. And if he declines, at least give a reason why.
Thank you. Now, this request for hearings, as I said, a lot of people outside, even, you see, the problem is everybody is jumping on the adjudication bandwagon, lawyers, claims consultants, overnight everybody is an adjudication specialist, But the thinking is still very, litigation-like or arbitration-like, And always they feel like there's a right, and they want to have a right to cross-examine. Like one case, I want to cross-examine the key witness, I want to do it. At another request, I want hot tubbing. Both parties wrote, we want a hot tubbing of both our experts, Forgetting the fact that, at the end of the day, is the tribunal, the so-called experts are basically helping the tribunal. It's not they're supposed to be independent, rather than coming as just party appointed, Now, we say, okay, yes, you can give reasons, but the problem is, are there any guidelines an adjudicator can follow, from case law, whatever it is, how exercises his discretion, because it's very subjective, on reasonable grounds. What reasonable grounds, okay? So one of the guidelines I thought, correct me if I'm wrong, Daniel, Kevin, and Yuen Fong, was Court of Appeals, I think, decision in the Seigel's case, isn't it? Where they say, if application is made early enough in the proceedings, okay, the adjudicator should actually consider it before turning it down. Whereas if it's made very late in the proceedings, then I think adjudicator, correct me if I'm wrong. I'm putting it in a very rough form, So again, when was this application made? You see, a lot of adjudicators, when we do the training of the adjudicators, we basically train them on going through the act and this and that. We don't actually train them the procedure itself, A lay adjudicator, an engineer, doesn't know how to actually even have affirmation or anything done, you see, okay? And any affirmation done, or an oath, he doesn't know how to do it. Then he doesn't know how to limit the hearings. Here we say, remember, you're given the power, whether first thing to hold a hearing and second thing is to limit the hearing. He doesn't know, you see. And if you do not know how to do it, you lose control of the situation, because parties have said something, you have not taken it down, you have not considered it, you're going to have a problem. So I also have come across cases where I have adjudicators who have call me up, lay adjudicators, sir, applied for hearing, I don't know what to do. I don't think so I should carry on with this case, I better resign, see. I mean, that's not a very good way of doing it. In the first place, you shouldn't be practicing as an adjudicator, isn't it? Yeah? Because these are kind of things you have to pick up. And all of you, those of you adjudicators, we find that even for AIC, when we were running the CPD courses, very few people are actually willing to develop it further. These are the kind of skills I think you have to develop, you see. Okay? So putting it in short, I think through case law, there are certain guidelines been laid out, and I think you have to follow the guidelines, Like, for example, you cannot say, I'm not going to have a hearing because I've got only very limited time to prepare my award. I think no court is going to accept that, No court is going to accept that, So, as what Daniel suggested, if you're going to have hearings and you can conduct them. Then if you anticipate that it will have impact on your delivery of your decision, before you agree, try to get an extension for the parties. Extend your time for the delivery of the, you can do that. These are some of the practical steps you can take. Yeah. So what do you think, gentlemen? One sentence answers, Daniel, Kevin, and Yuen Fong?
Well, I think the bottom line must still be that the hearing is required, and you as the adjudicator have to decide whether the hearing is required, even if the request is made early enough.
Agreed. It's really depends on whether the adjudicator requires clarification or of the submissions. But if you do agree to the request, make sure that you build in an extension of time, or at least for the time limit to deliver the adjudication decision. The 45 days starts only upon the completion of the oral hearings. At least protect yourself that way if you can.
I agree with you.
Yes.
Try your best to get it clarification by written submission, I think.
But what if the parties insist? One party insists, he said, no, that is a key guy. He made an allegation of forgery, I want to cross-examine him. So what would you do then, I mean, as lawyers, I think it's very easy for you, how to goreng your way out, But I'm talking quite a bit of the lay adjudicators, Yeah. So how do you think he should approach this topic?
Well, yeah, I think the adjudicator has to make a decision, make a call as to whether he or she thinks that the hearing will be beneficial for their decision-making process. If not, then don't allow the hearing.
Yeah, if the decision hinges on that oral hearing issue, then probably he has to hear it. If it's just minor thing, no. I think he exercised his discretion not to have a hearing.
Kevin?
Agreed, sir. I stand your ground and I say so respectfully. If the oral hearing is not of any benefit to the adjudicator, then my view is the answer should be no, and to get on with the process.
Okay. Now, moving on. Also connected. These are some of the problems which we are facing over the 10 years. It's coming up, because we never thought it would go along the way. I'm beginning to see more and more applications for specific discovery being made by parties in adjudication. Those of you who are non-lawyers, this is quite common in arbitration, and quite common in arbitration, quite common in litigation. One party says, so I want to have this document, makes an application for specific discovery. Now, under Section 25, the adjudicator has a power to order parties to disclose certain documents. The way I interpret it, doesn't say it, but either on his own volition, I feel, or if he feels it's necessary. Now, have you come across such applications? If not, if such applications are made, what should an adjudicator do? Daniel?
Well, I've never had to deal with an application for discovery in any of my adjudication cases so far. But if there is such an application, then just have a look at it and see if there's any merit in the request for the discovery. And if I find that there is merit, then I will allow the request for discovery.
But for that, where can the adjudicator find some guidelines? Don't you think he should ask the parties to submit, even legal authorities to support?
Yeah.
Or some authorities. You cannot run away from it, isn't it?
Yeah, that's right.
So one of the ways is a party make an application, ask him to submit, make a proper application together with authorities, give the other party a chance to answer. But here you see you're working within very tight timelines,
Yeah.
Okay? You cannot unilaterally make a decision without even hearing the other side,
Correct.
I think this is something you have to be very careful about, So
yeah, you have to go through due process. Yes,
due process. So authorities, then you make a decision. Don't worry, right or wrong, this and that, If somebody feels that you're wrong, well, but you have to make a decision. Kevin, what's your view on that?
Agree, sir. If a party were to make a request, then I will direct that that party puts in an application, and I will direct a reference procedure, and I'll keep it to very short timeline, say 2 days, 2 days, 2 days, and a decision in 2 days as well. That'll be the only way of getting around it without impeding the party's request for documents. Putting up a procedure, giving both parties opportunity to ventilate their reasons why a document should be or should not be produced, and a decision that is structured around a written procedures. So at least then, even if it's challenged at that point in time, the court will have something to see that at least there was an opportunity for an application, for a challenge, and a decision process, all within one set of boxes or set of boxes.
Thank you, Mr. Yuen Fong.
Yes, I agree with Kevin. Time, you need to give them a very short time to submit the application and for the other side to respond, because time constraint to render the award. It's very difficult. I've never encountered this before, and I've never filed an application for discovery before, because most of the time the documents are all there already.
Actually, I have had on 2 occasions. So we never talked about it. So I also told them of the cost implications, Yeah, because cost also comes in again, you see. So one party, a party makes an application, and you also got to consider not only looking at whether you're going to grant it, issue of costs, Okay, now quickly moving on, also related to this, because in adjudication, normally for, say, for a progress claim, one of the defenses raised by the non-paying party will be the work is defective or not properly done. Okay, and they would request the adjudicator to attend a site inspection to view the defect, whatever, on its own. Now, under Section 25, adjudicator, you have the power, okay, to order a site inspection, to attend a site inspection. Now, the question is, lawyers, this is real evidence. Those of you lawyers will know this real evidence. And those of you who are lawyers also know real evidence, there are certain rules you have to follow. Otherwise, you can be in breach of natural justice also. Okay. The problem is a lot of lay adjudicators not aware of the rules. Okay. Because of that first thing, they straight away deny. They say, no, we don't want. We don't order it, you know. Or second thing, when they hold site inspection, they always, sorry my language, screw it up, you know. They don't know exactly. You see, they're only supposed to look only from the technical point of view, normally. They start looking into other areas and all that. Now, question is, you being an adjudicator, an application is made to you, how would you handle it? What would you request the parties to submit to you to enable you to make a decision? And would you exercise the inspection? And when you exercise the inspections, what are the precautions to be undertaken? We are not really going into evidence, real strict rules of evidence. Although CIPAA say Evidence Act doesn't apply, but principles of evidence also impact on your natural justice, isn't it? So, Daniel, any thoughts?
Yeah, and I think when it comes to site inspections, the view I have is that it has got to be something it has to be very technical, something so technical that it's not possible to properly reduce in writing for the purposes of the Section 9, 10, 11 submissions. And if it is very technical, the thing is whether I'm qualified to really look at the physical defect and make a decision as to whether it's defective or not. More often than not, if it is technical, I would expect parties to, or require parties to submit an expert opinion or view as to whether there is a defect or there is no defect. And then perhaps convene a site inspection to verify what the experts are saying.
This is a visual inspection only, you see. But instead of a site inspection, can you tell the parties, submit to me photographs, submit to me videos?
Of course, yeah.
You see, try to ask them to justify why it is required, you know. Visual inspection, why is it so important? Why other substitutes cannot? Telling them the fact that this being an adjudication, okay, is a very rough and ready kind of thing, okay. So,
yeah, that's why it comes back to what I said earlier. If it's only a situation where it really cannot be reduced in writing for the purposes of the Sections 9, 10, 11 submissions, then I would consider it. But if it can be done by way of photographs, then I would expect all that to be adduced through the Section 9, 10, 11 submissions.
Okay, thanks, Kevin. Your views?
Yes, sir, I agree. The purpose of a site inspection is only to verify visually, empirically, whether or not a particular assertion made by one party or the other can be substantiated by an actual physical viewing at site. And it is important to make sure that whatever site visit that is made by an adjudicator does not become a joint site inspection for the two parties then to take back and start submitting on in the adjudication process itself, which is a line that an adjudicator should not cross over. It's only to determine whether what one party or the other is saying in their submissions is correct or not. Say, for example, if there's a defect or if a particular item of work is not done or in fact done, but not for the parties to go there and then to start ticking boxes as if it were a joint site inspection, because that should have been done even before. So adjudicators should be very careful not to fall into that trap and to make the proper inquiries before agreeing whether or not to conduct a site inspection.
Thanks, Mr. Yuen Fong.
The adjudicator, on my part, I think has to inquire from the parties the purpose of the site visit, and it's just to have visual inspection or to get to know how certain things work, then yes, but the adjudicator must make it clear that when they go to the site, no videos or whatever of them walking together should be taken and all those things, so as not to be used in court proceedings for applications to set aside due to biasness or whatever. And the adjudicator also has to be very careful of what he says when he's on the site. So if at all possible, I think what Daniel said was good. Get them to get expert reports and to submit it to the tribunal for decision.
Okay, thanks. So just to summarize it, you have the power to order. Okay, you have the power. Either, you see, listen again, on your own volition on the party's application. If there's a joint application also, if one party makes it, even if both parties apply, you still you have a right to exercise your discretion. For you, because you're the party, remember, deciding on the issue, isn't it? If you feel you can make a decision based on other alternatives like, video recording, drone footage, or photographs and all that, that's good enough. Okay. Now, if, for example, you feel either on your own volition or after parties have raised it up, that is a very crucial, because I had one adjudication where the set off for the set off for the defects was higher than the claimed amount. So it was totally extinguishing the claim. So in that case, I had no choice. I not only did a own physical examination, but I also got them to get an expert to help me. Okay, to help me, So, but it depends on situation for situation. But as I said, whatever you do, you have to give reasons. And the reasons got to be reasonable under the circumstances of the case. I think the courts will be sympathetic. Okay, knowing very well what adjudication is all about. Now, one last question before we are already overrun our time, so we have to allow some questions on the floor to come up. Now, following view esteem, respondent can keep quiet, section 6, okay? And then what happened when it comes to section 10, he can throw the entire kitchen sink at you. Now, you as a claimant got only 5 days to answer, okay? So what happened? The 5 days is too short. And most claimants will ask for more time. They will ask for a rejoinder. Those who are legal people will know what a rejoinder is, okay? You see, High Court decision, I think was last year, said there is no right, there's actually no provision for rejoinder in the Act, okay? So parties got no right to a rejoinder. But again, if you read under section 25, the adjudicator has got power to extend time on reasonable grounds. Now, that is a question of rejoinder. Recently, there was a case on a rejoinder, the other party wanted to answer. He wanted a sir rejoinder. Gentlemen, we are going deeper into legal territory. What would you do? Because he alleged in the rejoinder, new issues were raised up. What would you do? Daniel?
I think the answer to the question is don't allow the rejoinder in the first place. Because you're opening up a can of worms. It's never ending. I think in allowing the rejoinder in the first place, there must be very good reasons for it. New issues have been raised, new evidence has been tendered. And if there is going to be a rejoinder, it has to be confined to those areas, new issues, new evidence. Again, sir rejoinder, if there's a request for a sir rejoinder, you have to take a look at the rejoinder and see whether new evidence has been adduced or whether new issues have been raised that are relevant to the issues that are already brought up in dispute, and then make a decision whether a sir rejoinder. But you have to put your foot down at some point in time. This can't be going on forever, because this is going to eat up into the adjudicator's time frame for writing the adjudication decision.
No, what happened if the parties say we agree to give you more time? Like what happened in this case? But we want to ventilate our case.
Well, if parties want to give you more time, it doesn't mean that you want to give them the right to put in a sir rejoinder.
You see, as an adjudicator, sorry my interruption, for lay adjudicator, It doesn't mean if the parties are giving you more time, you should keep on going on and on and on, Okay? You got to go back to find what is the purpose of adjudication. And as is mentioned, if anything new comes up, then don't consider it a full stop. You have to put a full stop somewhere, isn't it? Yeah. So, Kevin, what do you think of this?
This is one area where as a matter of course, if there's a request to put in a rejoinder, I will agree. And if the moment the respondent asks to put in a rejoinder, I will suggest to the parties that if you're going to ask for an opportunity for a rejoinder, then we agree immediately for a procedure for a rejoinder and a surrejoinder immediately for both parties to agree. So both parties will feel that they are both going to have one opportunity each post the adjudication reply. And what I normally do is I fix very tight timelines, either 3 days or 5 days. I try to keep it within 3 or 5 days. Agree to get the parties to agree to extending my 45-day time limit. And I also require the parties to put in a rejoinder to limit their rejoinder and the surrejoinder to only 5 pages each, so that it will not go all over the place, and their replies are limited only to a response to the adjudication reply and a response to the rejoinder. So keep it tight. Both parties will not have an opportunity later on to say that I was not given proper opportunity to respond. Both parties will be happy and they'll be satisfied. And I'll limit it to 5 pages. Make sure that I've had this one situation where I limited it to 5 pages and both parties came back with both of them came back with their rejoinder and the surrejoinder, font size 10, single spacing, and if I expanded it, it will go to 15 pages each. So make sure that you limit it to 5 pages each, and at least that's my practice, 5 pages each, normal font and normal 1.5 spacing. All right, but that's my practice, but to allow both the parties to have one final say each if they ask for it.
Okay, Mr. Yuen Fong?
I would think that once the response comes in, the 5 working days would be enough for the claimant to answer to it. And even if there's new issues, if they want
No, sorry, my interruption, Mr. Yuen Fong. They can throw the entire kitchen sink, because for Section 5, you can only claim what is under a specific provision of the contract. Here, they even come back with things like equitable estoppel and all these kind of issues, For a lay adjudicator, he doesn't even know equitable estoppel is and all that, you see. And to handle all these kind of things is not an easy matter, And, after view esteem, what view esteem says, the adjudicator must consider, has got a duty to consider. He can turn it down, but he's got a duty to consider. And for him to consider, the other party must have time to actually submit properly, isn't it? I think 5 days is 5 days is a very, very tight. So the impact of view esteem now is, you see, earlier on they expected. Remember section 6, you don't answer, you cannot raise it up. So the 5 days for you to reply is more than enough. Now you keep quiet. So in section 10, you throw the entire sink, the so-called set-offs at the other side. The other side got only 5 days to answer. And I've seen it in a final account case. It cannot happen. 5 days is not enough. Even as a lawyer, you work 24 hours, you cannot answer it. So inevitably, time has got to be enlarged, you see. First thing for the section, your section 11, you see, for the reply, you got to enlarge it, you see. And then new issues come up, you see. So that's what I'm trying to say. But anyway, your views,
I would limit it, definitely. Because of time.
Okay, carry on before not enough. Okay, sorry.
I think that's all I'm saying.
Okay, Sharifah, I think we got a few more minutes. Maybe 1 or 2 questions from the floor. If you can just point out to us, we can then try to answer. I was hoping to get about 20 minutes, but I think we have already cut into.
Hello. We have addressed most of the questions in the chat box, and we only have one question from Deborah. That is, how is an application for discovery made?
Daniel, would you want to answer it first?
Okay. Well, application would usually set out the documents required, and an explanation as to or the grounds of the application, setting out reasons for the application for discovery, why the documents required, and how will it benefit the adjudication if those documents or evidence are disclosed in the adjudication. If you want to look at the actual sort of format for these applications, I think the court rules have got some good guidance as to the format for these applications. Then the opposing party will be given an opportunity to respond to it, and then possibly a further reply from the applicant, and then you have to make a decision as to whether to allow the application for discovery. You know, just in very, very basic terms. I think that's the process you have to go through. If you're looking at the form or the procedure, then you can get some guidance from the court rules for this.
Kevin, thanks. Daniel, Kevin, Yuen Fong, you have anything to add?
Same, I fully agree. There's no real format under the Act. So just put it in your letterhead and write to the adjudicator and state the documents that you require, state the basic principles, why the document is required, whether it's in the possession and control of the other party, and the relevance of the document for this particular adjudication, and then wait for and ask for directions from the adjudicator.
Yuen Fong?
Just write in. There's no particular format, and use the rules of court as guideline for the grounds of your application.
So, gentlemen, do you see any relevance on the red fund schedule here?
For me at least, if I were the adjudicator, I would direct a red fund procedure, because it'd be so much easier. Everything is just in the set of boxes.
Tabulated.
Why you want it? Relevance? No, I'm not going to give it to you. A response? Decision. Short, sweet, and the main points are there, and it keeps the parties disciplined and to the point.
Okay. So I think there was a question from Deborah. If I missed it, it's to do with the training, is it? Oh, sorry, Sharifah, can you help me out there?
In relation to the training, we've already addressed the question as well. I'm not sure what exactly is the question Deborah has sent to you. I've asked her to resend it to the chat box for everyone's benefit. In the meantime, I'd like to highlight to everyone the links that we have placed in the chat box, which includes the feedback form for today's session, the registration form for BicTok 3, and another one for our sports arbitration. Deborah has sent the question, and that is, how do adjudicators deal with without prejudice letters and damages as set off?
Wow. That's a tall order question, but just to answer you, I think there's a recent, I think, Court of Appeal decision on this issue of without prejudice letters. Okay, without prejudice letters, and I think lawyers like Daniel, Yuen Fong, and all that can explain without prejudice documents or letters better than me. My understanding is, we always have a habit just to stamp everything without prejudice. Actually, it doesn't work that way. Without prejudice, documentation only comes in when parties actually trying to go for settlement, negotiating. And those documents cannot be submitted later. Okay? Correct me, Daniel, if I'm wrong.
Yeah, I totally agree with what you've said, Harbans. I think the underlying principle is whether it's covered by privilege or not. And without prejudice letters, don't look at the rubber stamp on the top of the letter. You need, as an adjudicator, you need to look into it, if necessary, to see whether it's really a settlement negotiation, which has not culminated in some sort of a settlement agreement or an agreement from both parties. If it hasn't, then these sort of negotiations cannot be considered as evidence in the adjudication. And of course, legal advice and the like are covered by privilege. Those are things that can't be used or should not be used in evidence in an adjudication.
So actually, basically, this is my view from whatever I've been in my practice of coming across. Just by stamping a document without prejudice doesn't mean it's going to attract the privilege. The onus will be on you. There are rules covering that. Without prejudice documentation. But on the other hand, if a without prejudice document is disclosed, then there's another issue. You see, that opens up another can of worms. So without prejudice documents, you don't disclose. But then if you want disclosure, and this is where discovery and all that will come in, this process will come in, you'll have to justify, you see, together with authorities. Yeah, next question to do with damages. That is a very, very wide field. How, to deal with damages as a set off, here, most of the damages we are talking about is LAD, you see, issues to do with LAD. Normally LAD, or the other one is for what? Defective work and all that, Here, I think this forum, I dare not give you a simple answer because there's no simple answer to give. Maybe Kevin has put up his hand.
No, so I meant to say that I agree with you. It's going to be very complicated, and perhaps I think a separate session altogether might be required just for this one answer, one question alone.
No, Deborah, for your information, you see, for everybody's information, we are going to have these BicTok sessions every fortnightly. Okay. The next one is going to be on sports arbitration. End of February, we are going to have one on court annex mediations. Okay. And then early March, we are having one on all these interlocutory application, discovery, things like that. Now, end of March, we are going to have on how do you handle claims, cost-related claims and time-related claims in adjudication and arbitration. Perhaps you try to attend that, because we are trying to actually, formulate this kind of talks and all that. And if there is enough interest shown, we can even hold a course, a half-day course or one-day course, At the moment, it is commercially not viable, you see, and that's the reason why we are doing the talks yet. But if we get enough people, we can always do, because this is something which will really help out, Those of you who want to learn, will help you in the learning process. Others, you hone your skills. Okay, Sharifah?
All right, that concludes our BicTok session for today. Can I just highlight that we had registrations up until 10 minutes before the session started. So the demand is there. We just need more people to spread the word and more people to sign up for a commercially viable training right here in Sabah. Thank you, Mr. Harbans. Thank you, Mr. Chin. Thank you, Mr. Kevin. Thank you, Mr. Daniel Tan. We hope you enjoyed our session, and please do follow us on LinkedIn for the next events. Thank you so much, everyone.
Thank you, everybody. For those of you celebrating Chinese New Year, Happy Chinese New Year. Those of you who are going to celebrate Vilaya Day, like us tomorrow, Happy Vilaya Day. And I would like to thank my fellow panelists who have taken off their time, shared their experience. I also like to thank Sharifah, Shuling, they have been the people behind, they are the most critical people. We just come and talk only, and most of all, we got to thank you, because without the audience, this thing cannot be a success at all. I hope, this is my sincere wish. Even if you have benefited 10%, just 1.5 hours like that, I think is something positive. And we should always try to bring professionalism, because I always keep on saying, whether it's arbitration or whether it's adjudication, the quality of the end result matters. And the quality can only come in when you're professional adjudicators, arbitrators, and not forgetting the people who are going to submit the case. An adjudicator can only make a decision if the submissions are good, you see. So that's where we need people like you to, help us in that. So again, thank you very much. I hope to see you on another occasion. Okay, bye.
Thank you.
Bye.
Thank you. Bye.
Bye.